Thanks, Patrick, for taking some time here today to talk about IP. It's good to see you.
Great to see you, Gene. Thanks for having me.
So why don't we start with probably an obvious question is, what are you doing these days? You were with the Chamber for a long time. I know you came to the Chamber job because of trade experience and so forth. So are you mixing the trade with the IP? What do you have going on?
You bet. So I came to the Chamber straight from the George W. Bush administration, where I served in the U.S. Trade Representative's office during what you might call the golden age of U.S. trade agreements. You know, we did Trade Promotion Authority. We brought the U.S. fully into the World Trade Organization. The North America Free Trade Agreement was at its strongest, and we executed trade agreements with countries around the world, really opening up markets for U.S. exports in a way that we had never done before. At the end of that period, you know, I went to the Chamber and had the chance to represent the private sector, doing the sort of the hands-on work of helping companies to actually access markets, to recognize what rules and regulations, you know, the trade agreements might not have fully been able to cover, and help them overcome the remaining obstacles so that they could be successful in markets around the world. That was a ton of fun. I went from there to the Global Innovation Policy Center, which I led for a number of years. And after 15 years, I'm really excited to be out on my own. I'm continuing to serve the innovative and creative communities through Kilbride Public Affairs, where, you know, we're representing the innovation story of cutting-edge American industries to the U.S. government and to the world.
Yeah, that's got to be exciting time for you. I know when I embarked upon my own path, you get the opportunity to do what really helps you get out of bed in the morning. It can be very, very exciting, and it sounds like you're doing some really good work for folks.
I think there's a ton of interesting opportunities. One of the things that excites me is a chance to reframe how people think about innovation. I think that's what often has brought us together. And, you know, I so much appreciate IPWatchdog and you and Renee and the chance that you've given me to talk with inventors, with law practitioners, and really thought leaders from throughout the United States who are at the cutting edge of keeping the U.S. inventive, keeping the U.S. innovative, keeping the U.S. at the forefront of technological developments, and allowing me to play some very small role in that conversation.
Oh, you've played more than a small role. You've been great, and your articles have been great, and hopefully we'll continue to publish your articles. I think the thing that I always find interesting about our conversations is the economics, the market, the trade component to IP and innovation that you see that I don't always necessarily see. You know, as being a patent attorney, there's an old saying, you know, when you are a hammer, the world looks like a nail. So I always find it very interesting to have conversations with you because you pick up on certain things that I think a lot of IP professionals may not pick up on. And I know one of the things that we've talked about over the years is this idea of what it actually means to be innovative. And I fundamentally think a lot of people misuse that term, innovation. But what say you? Let's just pull back the layers of the onion here on innovation. What does that mean to you?
Yeah, thanks, Gene. You know, I often have to say in these conversations, because I'm not an attorney, I'm not an IP practitioner, and entering into these types of conversations with the real experts in the legal field, I often have to say I'm about to betray my ignorance. And I think that's a double-edged sword, right? It's both been a strength and a weakness for me. You know, if I get into the real legalistic conversations, you know, I tend to have to try to play catch up. But on the other hand, I'm able to bring that broader economic perspective of let's think about how markets actually work. Let's think about the objectives that our policies and laws are intended to achieve, and then let's marry the legalities with those broader economic principles and and socioeconomic objectives that we want to attain, and really help people to think again, maybe if they've gone down a path that looks like a dead end in terms of policy. So the same is true with innovation, right? When we talk about innovation today, we tend to think very legalistically. Well, what does the law say that innovation is? Innovation is anything new. And I always have a mantra: innovation happens everywhere. People are inherently innovative, or at least they have the desire to innovate. I think that's a shared part of our human nature. And so often, some of the most creative expression you see is children playing. They'll always find new tools, new games, new ways of amusing themselves. But the problem, we have globally and historically is that innovation has usually occurred as a one-off, maybe as a flash of brilliance, but it hasn't been able to be sustained or consistent because for most of human history and in most places in the world today, unfortunately, the conditions were not present to enable an investment in sustained and transformative innovation. What we've seen, I think, in the United States and in the Western world, in part because of our commitment to private property rights and including extending those to intellectual work, you've seen the ability to invest and sustain an investment that leads to transformative innovation over time. What happened was innovation, invention used to be the province of the aristocrats, the independently wealthy, or someone who had a patron in a royal court. What the U.S. system did was to democratize invention and innovation, to say we're going to make rights available to anyone who can do something innovative and allow them to invest themselves, not as a hobby, not as a sideline, but as a living, so that if they come up with something new and of value in the market, I won't say new, novel, and non-obvious. We can talk about utility and obviousness later, but you're doing something new and valuable in the market, and we're going to make sure that you can be rewarded, that you own the rights to your work, whether it's in the creative space or the inventive space, or maybe as we can talk about later in terms of broader sort of intellectual work product that may not be covered by IP rights today, that there should be a path to ownership, a path to return on investment. And that when we do that, when we achieve that as a society, then we unleash all of that power of hundreds of millions of individuals in the United States, 8+ billion around the world, to be the innovative and creative powers that they were born to be.
Yeah. There's a lot there. And hopefully we can talk about, a lot of the bits and pieces that you've brought up. But the one thing that keeps coming up in my mind is the misuse of the word innovation, I think. So when you're talking about, kids find all kinds of interesting and new ways to keep themselves occupied, and we laugh. Renee and I laugh sometimes. We have 4 dogs now, and often the toy in air quotes that they will pick to play with is the box that the toy that we purchased for them came in. Just like kids, the boxes are always playthings, and for them, they get so excited. They get a wrapper on something, or bubble wrap, and they can't wait to squish it. And dogs and kids are the same. They're very creative, right? And for them, it's the first time that this has ever happened. So it's very exciting. But the first time for them doesn't mean that it's innovative. It just means it's the first for them. And I think a lot of times people. And I think sometimes it's intentional, and I think sometimes people just don't know any better. But innovation is supposed to benefit society, and redoing what somebody else has done, only in your channels of commerce or in distribution, doesn't really qualify as innovative. It might be a great business decision for you, but it doesn't qualify as innovative. So what do you say to those people or that definition?
So I think you're right, and that speaks to a definition of innovation that may be overbroad. On the other hand, a definition of innovation that is overly legalistic, that looks at court rulings on novelty, utility, non-obviousness might get a little too narrow. I think of innovation as something new that adds value. It could be something entirely new, a direction that's never been conceived before, or it could be a new and valuable improvement to an existing product. I think it was the Patent Act of 1790 was the very first law passed in the United States, and specifically said for new inventions or improvements to existing ones. I don't remember the exact words, but I think that's really important. Is we have to be able to, in order to have sustainable innovation, to be able to keep investing in the new things. And the investment piece is important to me. I'm not so worried about somebody having a property right to something they stumble across by accident so much as I am in ensuring that we enable people to own their own work. I think it comes back to one of the most fundamental principles of economic and individual liberty is this idea that you own your own labor. It doesn't matter if it's physical labor or mental labor. Somebody can't force you to go to work for them. That's slavery. And by the same token, they can't take the work that you've done. That's stealing. It doesn't mean that all work has equal value. That's for markets to determine. But your work is yours.
Yeah, and as a content creator, I totally get that. And I think a lot of times, the first time that Joe Average comes up with that understanding is when they created something themselves, and then somebody takes it, and they're like, "Well, that was mine." Well, it's not yours if the law doesn't recognize what you did as leading to some kind of property rights.
I think that's an incredibly important point, Gene. To recognize that property rights are not a natural right. We can talk about natural rights in terms of, life, liberty, and the pursuit of happiness, but property is very much a construct of law. And, without those laws and without those property rights, you have a system of, basically slavery, right? The old feudal system where some people controlled all the resources and everybody else was subservient to them. Property rights is the great equalizer. It enables people to own their own work.
Well, and to invest, right? I mean, I don't think there's any special sauce to the American experience or the Western European experience when it comes to owning things. But you look around the world, and most of the rest of the world, people don't really own things, certainly not in the same way. Like, for example, I'm thinking in a lot of third world countries or in countries where there is a dictatorship or a totalitarian regime, you don't see the investment in even real property because you don't know for sure it's going to be yours tomorrow. And you saw that happen in U.S. consciousness because it only happened 90 miles away in Cuba when Castro took over. I mean, that was a thriving economy that just came to a screeching halt because people didn't believe necessarily that what they had today was going to be theirs tomorrow.
That's exactly right. And I think one of the most remarkable things about the American economy is that what we have done historically does seem to be so unique. What was that? It's, number one, we enable risk-taking and failure. Number two, we foster competition. We ensure that goods and services can cross state lines, for instance. Number three, we provide property rights. Number four, we surround those rights with rule of law. And number five, we make markets. And the fifth one is almost, as important as all the others. We are better than anyone else in the world at mobilizing resources and making them available for investment in new areas. And I really equate, I think this is especially true of the intellectual property space, which is why I mentioned here, intangible assets, ideas, innovation, it's like shale oil. It's there, it's latent, but you can't always access it until the conditions are right to enable it to be utilized. In the case of shale oil, it meant technology catching up and price. You had to have a certain price level before it was economical to bring it out of the ground. The same is true of innovation. You have to set those conditions where you can access all of that private capital, and then you can use it for the high risk, the high end deliverables that really change the world. Those technologies for energy that are going to tackle climate change, the new cures for HIV and cancers, the new modes of food production that will feed 8 billion plus and growing people around the world. Those are all possible because the U.S. has enabled the allocation of resources to these high-risk, long-term, capital-intensive projects.
They are, and the innovation that we want is extremely capital-intensive. Mm-hmm. And there's nothing wrong with people inventing something that, as seen on TV or QVC, or that you would find in Home Depot or something like that. I mean, all those innovations are great, and they play a role, and they make life easier and so forth. But the ones that we as society really benefit from are very difficult to do, have usually long runways from the moment of invention to commercialization, and then even beyond that takes longer to get to any kind of even break-even point. It's just getting more and more expensive to get that kind of innovation that helps society.
Well, so yes. Yes,
like a vaccine.
Yes,
example.
And I think if we don't apply the economic principles that allow that transformative innovation to happen across the board, then we don't get the transformative innovation. So I'm thinking of, you and I always hear the story of Josh Malone and his water balloons, or Molly Metz and her jump rope, or so many other, individual inventors. And unless we provide those principled property rights to inventors of every scope, scale, and characteristic, we don't preserve that principle for the big transformative innovation, because then it becomes, sort of an industrial policy type system. We're going to pump money into drug discovery, and then we're going to build all sorts of rules around that. And you see that taking place today with all the restrictions that are being placed on federal funding of university research, for instance. It's really important, I think, that we have a very principled approach to ownership of intellectual property that is broadly applied without distinction, without favor, and then we'll see that transformative investment happen as well.
Yeah, I hope so. I shared this with you earlier when we were talking before we started recording. It feels a lot of times like we're shoveling water back into the ocean, and so and I'm cognizant of the fact that a lot of these old sayings that you heard from your parents, or maybe even more so from your grandparents, they're old sayings because they're true. Right, and the one that has come into my mind lately a lot is it's always darkest before the dawn. And I keep trying to remind myself that. And in my life, at moments when I thought, things were not going well, personally, professionally, whatever, if you keep persevering, it has a way of working itself out. And usually you're better off in the end. But it does look sometimes pretty bleak right before the dawn. And I keep wondering in this space, how much darker can it get before we have dawn? And because I see the rest of the world making what I perceive to be good choices, not all the rest of the world, and even in places where they're making good choices, I think they could be better, but they're certainly different than what we're doing now, and it feels a lot like those other countries, China, much of Europe, much of South America, are making choices the way we used to make these choices. And that's why it's frustrating. It feels like we have forfeited our lead for no good reason.
When you look at the international space, it's always interesting. First of all, no country is monolithic. So, you see a decision from a government. Usually it's a government that may be in power for a certain amount of time. I mean, even Xi Jinping in China was not always president. He won't always be president. There is change. But, so you see temporal decisions. The government of India decides to do something, and then 5 years later, another government in India does something different. But both temporally and within governments, there are competing points of view, and you often see those competing points of view working not always at cross purposes, but with different objectives in mind. And so, as an advocate for innovation policy around the world, I've often had to appeal to people in economic ministries, for instance, who understand sort of some of the more pragmatic aspects of foreign investment, of trade and markets, and ask for their influence in broader government decisions that may affect a specific space like digital trade or technology or healthcare, for instance, where they're making decisions based on more specifically social outcomes. And one of the opportunities we have is to point to U.S. history and say, look, here's what we've done well, and here's what's happened when we've done it well. When we've, provided property rights, surrounded them with rule of law, and enabled markets to work, this is what happens. And there's a historical record to demonstrate the effectiveness of that. I think, to your point, a lot of countries around the world have seen that and have tried to emulate it. On the other hand, then you have the rhetoric coming out of the United States that, well, maybe intellectual property is discretionary. Maybe it's just a reward. Maybe it's not really linked to innovation, and we're undermining those decisions that they're trying to take.
Yeah, and even the Supreme Court, they said in oil states it's just a government franchise, which I don't get where that comes from. I actually was just looking at the oil states decision this week, and they cite some very old cases, but they had to ignore a bunch of more recent cases where they said the exact opposite. And the reason why I was looking at oil states recently is because the SEC decision by the Supreme Court this last term, where the SEC is not allowed to conduct trials that lead to civil penalties, that you have a right to a jury trial. I read that decision and juxtaposed it right next to the oil states decision, and it's like they're written by two totally different people. I couldn't believe that they could come from the same court within such a short period of time. In the SEC decision, it's the right to jury trial is fundamental. It's so important. If we're going to do anything to abridge that, it's got to be really clear and really significant consideration and very important and only rarely justifiable. And none of that seemed to be found in their oil states decision, where they said patents are a government franchise. Because I look at, if you can't get a civil penalty from an agency, because penalties should be adjudicated by an Article III court, the ultimate penalty to me seems to be losing your patent right. And the way that the Supreme Court seems to have made the distinction not in these two cases is that, well, it's not that you're losing anything, it's that you never should have got it in the first place. So we're just setting the record straight here. And to me, it's like, wow, that just seems to fundamentally misunderstand how innovators and businesses and investors need and rely on a certain patent system and a certain patent right. And I almost don't know how to articulate. I mean, we can have a conversation, you and I, we always do, we have with other people, but how do you break through with that message to Joe Average, or maybe not even just Joe Average, but Joe, member of Congress, assigned on a non-IP related, non-innovation related set of committees, who's interested in what's going on in the farmland or in the national parks or you name it, right? How do you get that person to look at this issue with fresh eyes?
Cognitive dissonance is alive and well in public policy, that's for sure. I always go back in terms of making the point that you're making to tangible examples. If you were to purchase a car and you were required to leave your car on the curb with the keys in it, how much would you be willing to pay for that car? It would be only as much as the value of whatever task you had to perform from the dealer's lot to your destination, because after that, presumably somebody else is going to get it and drive away. The same is true with investment in innovation ideas. You're only going to invest as much as you think the value of your ability to hold on to it is, either because the law protects it or because you have enough of an internal firewall. The purpose of law is so that we don't need to have those firewalls, that we don't each individually have to live within a fortified compound to protect our family and our possessions. The law provides that. The law provides that protection. And so whether it's an automobile or a company building a factory and filling it with useful equipment, you can only make those investments if there are laws that protect them. Otherwise, you have to resort to spending excessive amounts of money on defense.
Right.
The whole purpose of government is so that we don't have to do that. That the law replaces the need to do that, or the need to rely on somebody else to provide protection. That protection racket that you and I talked about.
Yeah. It's supposed to be there to enable things that otherwise couldn't happen, but for the cooperation and collaboration that the law sometimes imposes. It's like, for example, the classic example is none of us could go out and hire our own fire department just to stand at the ready, but all of us could get together and say, hey, having a fire department is very important. We'll all pitch in a little bit so that we can all benefit from that.
And the broader benefit is that we're not just protecting our own investment, we're enabling economic transactions. We're enabling all of us to do business with each other. Because of that property right, whether it's your car, a house, an idea, you can use that property right as a vehicle to do business with someone else. We can agree on a value that we're going to assign to this piece of property and say, I'm putting this on the table. What are you bringing to the table, and what value do we assign to it? And those values are ambiguous. That's how markets work. They set values based on individual transactions, but the property right enables you to come together and have that negotiation. Absent that right, it becomes very difficult to do business together at all. I think that when you talked about secret sauce, that is kind of the secret sauce of the U.S. system, is we have this property right environment surrounded by the rule of law that enables us to do transactions even with complete strangers with confidence. And so that creates a liquidity and a dynamism in our economy that's really lacking many other places in the world. And that's what's at risk right now, is that economic dynamism that has been so unique to the American experience.
I agree. I want to pick up on, you've mentioned markets a number of times, and you really just explained it, I think, very, very well. And I want to circle back, though, to put some context into what you just said and see where this leads. Because I'm sure you've heard there, like, people who tend to have more of a libertarian kind of view of the world will often say that the innovation and intellectual property space is not a market-based space. And when they say that, I kind of scratch my head, and I really don't get it, And then when you talk to them long enough, I kind of sort of see where they're coming from. Although it seems to me that they're missing an awful lot, right? Because what the system we have versus the patronage system that we've talked about here a little bit is, in the patronage system, some wealthy person, sometimes it was the king or queen, or some wealthy noble, will decide, hey, Van Gogh, I really like your paintings. Why don't you come live at my estate? You can paint all day long. And that's what gave these artists the opportunity to then spend all their time painting. But that creates a limited amount of creativity because it's tethered to the taste of the individual who is the sponsor of the work. Not to say there's anything wrong with that system. And if you got enough money and you want to sponsor people, please go for it. I think that there's definitely a role for that even today. But as a way to maximize creativity, that doesn't work. And it doesn't allow us to decide what should be maximized. What should be or shouldn't be maximized is left in our system to the market, to the purchaser, the people who are at the other end say, hey, I want more of this, we want less of that. And they don't have a vote. There's no national referendum. It's just they buy A and they don't buy B. And then people get the idea, okay, well, I'll make more A and less of B. So I see an enormously market-driven system. But they'll say that it's not because these rights are just made up. They're made out of whole cloth. And if it was market-based, then I would be able to do anything I wanted to do without you telling me I couldn't do it. And that I don't know that I think that that's libertarian as much as it is not naive, because that can't possibly be the result. Because if you can't make money doing it, you can't do it.
Well, what you described, where people just do whatever they want, in economic terms we call that laissez-faire, right? Mm-hmm. But in broader terms, it's just a state of nature. In the absence of government, in the absence of laws, we all do what we want. If I'm stronger than somebody else, I can take their things. If somebody else is stronger than me, they take from them. And this is how society worked for millennia, right? The strongest, organized their political bloc and offered protection, and everyone who lived under their umbrella was subservient to them. And they fought against the warlord next door and tried to protect what they had from that guy who's doing the same thing to his, quasi-slaves. The whole purpose of government, in my point of view, is to create that legal construct that gives us all rights where we don't have to constantly expend the vast majority of our energy in defending what we have. Rather, we can put that time and energy to productive use. If you've got to have rights for mental labor as well as physical labor to allow that to work in an economy today that is dominated by knowledge, information, data flows. This is not only the assets of today's economy, it's driving the productivity of the physical assets as well. So if we can't own those intangible assets, then we effectively are back in that sort of feudal system where we're beholden to somebody else.
Yeah, to me, it just seems so clear that you have to protect these things if you want them. If you don't want them, then don't protect it. People make largely rational decisions. And at this time of the year, with the presidential campaign and cycle, you always hear people talk about kitchen table issues and that sort of thing. But that's the way people have always made decisions on their own, is what resonates around the kitchen table that affects them. And if you want people to do more of something, you have to make it feasible for them to do more of that thing. And if you want them to do less of something, then you put up all kinds of walls. And I just see the innovation system right now as benefiting the large incumbents. And I don't really have any ill will against the large incumbents, because if I was a large incumbent, I would be advocating for those positions too. I just wish that we had some people minding the shop who looked at not what was just good for the large incumbents, who do employ an awful lot of, in this country, we'll talk about Americans, since it's a presidential cycle and that's going to be the issue here, right? But you also want to be able to foster a climate for the next generation of companies that could or will become large incumbents. And I don't see a lot of SMEs or startups becoming large incumbents in this ecosystem.
In an ecosystem, a healthy ecosystem, a functioning ecosystem, you envisage a diversity of stakeholders all doing their own thing, but not necessarily even consciously working together, but operating in such a way that there's a whole that's bigger than the sum of the parts. And I think part of the problem with some of these incumbents is that there's vertical integration to a degree that there are fewer and fewer stakeholders as part of that particular ecosystem, and if the big incumbent is gobbling up other stakeholders as they emerge, then that never changes. Where I see healthier dynamics is in ecosystems where, for instance, you have government playing a role in steering or encouraging research in a certain direction, maybe towards national security priorities or economic or social priorities that are unmet, but sort of seeding the system. You have research universities using those federal funds to do cutting edge research at the knowledge advancement level. And that are bringing up the next generation of researchers through their educational capabilities. So you have both knowledge advancement and knowledge diffusion, and then you have a private sector component of that ecosystem where some of those new ideas are being commercialized. Where the asset or the access to capital exists, where they can make the big investments, where they have the long-term horizon, and they can take those new ideas and carry them forward, whether it's often beginning with the startup, but then as you need to achieve scale, going to larger and larger players, and ultimately to the capital markets, whether it's public or private equity, venture capital, there's this whole ecosystem that works together. And I think, in those spaces where the big incumbents, it's all internal, you don't see nearly as much dynamism. And that's what tends to be missing when the property rights system breaks down, because the people who are creating the new value added don't have the opportunity to capitalize on that. They're forced to give it up to that big incumbent in order to carry it forward.
Yeah, and this may become a larger and larger problem in an AI world where it seems like the amount of money it's going to be required, at least right now. I mean, maybe this will go down over time as the technology gets matured, but to create and then use the AI tools is an enormous amount of money that is required to be invested. And if only a handful of players control that marketplace, that will again be a way that the large incumbents continue to exclude competition from more junior members of the industry.
Maybe Pac-Man was the bad guy.
Yeah,
gobbling everything up.
Yeah, I don't know. I mean, on some level, I don't have a problem with companies. I almost think that if they're buying these other companies, that I have less of a problem with that. Although it can still lead to the same kind of issue. But I think what we've seen an awful lot of is some of the large incumbents kind of leading companies on, thinking that we're going to do a deal with you, show us what you have, and then once they learn enough from you, then talk stop, and then they copy you. And that's sort of the theory behind the Apple Massimo case, right? And that Massimo has won a number of decisions there, and they still don't seem any better off now that they've won along the way. But there seems to be a reluctance on the part of the courts to say what these large incumbents are doing is wrong, and no, you need to pay that smaller entity that you're damaging. And I feel like it's because the math is the math, right? But if you only have a couple of players doing something that then everybody wants, like whether it's an iPhone or iWatch or an Android phone or those types of things, there's only but a few players. So if there's an infringement going on there, the amount of money that each one of those few players is going to have to pay maxes out anything that even comes close to what the Federal Circuit would allow. Whereas if there were 1,000 players, I think the Federal Circuit and people generally would be fine if each one of those 1,000 players had to pay, $1 million. But if you have one player that has to pay $1 billion because they own almost the entire market, now that's a problem. And to me, just the math can't make it a problem. Who's paying it can't make it a problem, because you look at the piece of the pie that those few control, and it's gigantic. It's totally enormous. And but that's where we stand, I think. I mean, am I wrong? Do you have a different view?
It's a question of scale, right? If there's one big player, they can afford to pay more than 1,000 small players. But I think what we've seen is a downward spiral. What we see is when property rights are weakened, companies stop relying on property rights. They look for other ways to access what they need, and they look for other ways to protect what they have. And so, I think the lesson that American corporations have taken from the weakening of the patent system is that they should, it's sort of like inflation expectations, right? You expect more of it. And that leads you to make choices that, further weaken the patent system. I think you and I have often had the conversation that incentive to innovate is wrong-headed, that, people don't really need an incentive to innovate, but perhaps they do need an incentive to use the patent system to make that the way that they protect their rights, so that we're attaining those social benefits that come along with it, of disclosure, of knowledge diffusion, of technology transfer, and that it shouldn't be quite so easy to just hoard your intellectual property in the form of trade secrets, although they play a very important role as well.
Yeah, keeping a secret does not benefit society, because by definition that means society doesn't know about it.
Exactly. That's what the guilds did, right?
Yeah, and I don't begrudge anybody who's making the choice for trade secrets right now, because I think it's, in a lot of regards, it's the logical choice to be making. It's just not the choice that maximizes the goal as announced in the Constitution, or starting with the first Patent Act. And also, the history is lost, right? I mean, George Washington's first address to Congress, first State of the Union, was only like 1,000 words long, and he spent like 100 of those 1,000 words talking about the need for a patent system. So this is not some radical, crazy idea concocted by a bunch of people. And one of the problems that we also have in the industry is they all understood, they being the founding fathers, all understood how important this was. So that particular clause in the Constitution, we have almost no history on, because it comes up and everybody, oh yeah, okay, that makes sense. Next. I mean, they argued about everything except for that clause.
I mean, that's right, Jay. This is part of the defining character of the United States, that we're going to provide and protect the private property, the labor of individuals. I think it comes back to the point you were making just a moment ago about, how decisions are made, at the kitchen table by all of us who collectively represent the market. And I think one of the sort of challenging legacies we've been left with, is this idea of the market being the invisible hand, which makes it sound very sort of amorphous and maybe a little scary, when in fact the reality is it's very visible hands, 330 million pairs of hands in the United States and 8 billion hands in the world, everybody making decisions about what's in their best interest, what value they attach to different goods and services that they might spend their labor and their money on in the marketplace. So we are the market, and we need to defend our ability to be the market and not hand off the right to make those value decisions to somebody else, to a political elite. I think that's what happens in China. Economic decisions are made top down instead of bottom up. And so what does that mean is that they have the advantages that they have a tremendous amount of focus and control and can drive resources to a particular objective. But the corresponding weakness is that they have one idea. It's handed down from the top. In the United States, we have potentially hundreds of millions of ideas competing to see which one's best, which one the market places the most value on. And I believe our system is the one that wins out at the end of the day. But we don't beat China trying to do better than them what they do so well.
No, I agree with that, and I also think the cream rises to the top if it's allowed to.
Mm-hmm.
So like if you set the laws in a way so that everybody has an equal playing field, and these are the rules, then you will get the best that does percolate to the top. It's when you have anomalies that it doesn't work out so well. And I see a lot of anomalies. And one of the things, and not that it necessarily is related exactly to what we're talking about, but I think sometimes in this whole conversation about intellectual property, innovation, markets, everything, we so totally missed the boat. It's like, and lately what's come to my mind is, and I think I articulated like this recently to somebody, and it's like, you remember what jump to the shark means, right? That was when Fonzie jumped the shark, and that kind of is synonymous with we've done everything, and now, oh my God, jump the shark, right? The jump the shark moment that I had recently is in this whole debate about AI. Can AI be an inventor? Should AI be an inventor? Can it be a co-inventor? How do you use it? How do you disclose it? We are so missing the boat because we have AI tools and AI technology that the patent office won't even allow a human to patent because it's abstract, which, by the way, is why AI works so well, because it is abstract, because it does things that we didn't tell it to do, like in machine learning, for example. And it learns. So it's abstract by its nature, but because it's abstract and because that's the whole point of it, you may not be able to get a patent on it, human being. But let's talk about whether the AI can get a patent on what it creates. And it's like, whoa, talk about jumping the shark.
Well, we get so caught up in the conversation about, how were the AIs trained? Were they infringing, proprietary content? Probably yes. Almost definitely yes. Is the output infringing? One certainly imagines so. I think what we see is, in general, the business community at least saying, we've got laws in place that address a lot of these issues, so let the courts work it out. I'm okay with that on the whole. What really interests me a lot more about AI and intellectual property is how we can use it to optimize the system of providing and protecting rights and giving them additional clarity and legal certainty. And I think the huge opportunity in front of us, especially in the patent space where I think it's desperately needed, is to be able to characterize and categorize different patent applications, different claims within those applications in terms of how they relate to every other patent claim that's ever been made, and really to have very clear lanes to understand where the cutting edge is in all of these different operating areas, and really bring a degree of clarity to the patent space that's been missing. I think the reason that this so-called patent troll behavior or efficient infringement, on the other hand, is able to perpetuate is because of all the ambiguity between very closely related claims, some of which may be more narrowly written, some of which more broadly, but inevitably they overlap, and it's just a huge mesh. But with AI, maybe going forward, it might not happen tomorrow, but maybe in 10 years, we have the ability to really create that really crisp, clear, map of what's been patented.
And it's funny you put it that way, because what I always tell people is if you go back certainly 100 years and certainly 150 years for sure, patents were like 2 pages long. And that included the drawings, 1 page of drawings, 1 page of text, including the claim. And the claim would be something like, I claim what I have disclosed. There was more words to it than that, but it's largely what we would call an omnibus claim today. And everybody knew what the inventor had invented. Everybody knew what the patent covered. And now patents can be hundreds of pages. starting to see many dozens. Maybe I saw a patent application filed recently with over 100 figures. Lots of good reasons to do that. I tell people they should, more figures is better. Everything the figure shows is disclosed, etc. And then a long, detailed set of claims. And somehow along the way, nobody really knows what the inventor invented, and nobody really knows what's protected, and there's no boundaries. It's like, how did we screw up so bad that a 2-page document everybody understood, and now a 100-page document that's more detailed provides less information?
It's like when Nancy Pelosi said, we have to pass the bill to find out what's in the bill.
Right. That was a Washington gaffe because it was honest.
Right. So here's a goal for the IP community writ large, USPTO, WIPO, everybody in space, is we should set a goal where some point in the not too far future, there will never be a surprise in patent assertion. If somebody is bringing a claim, trying to enforce a patent against you, or claiming that they don't owe you royalty fees, it should be a pretty straightforward argument about the validity of one claim or whether it truly is infringed, and not whether not a surprise. Right. Nobody should be surprised.
Nobody should be surprised. But and I won't say who it was, because I'm 99.9% sure he said this on the record on this stage during a program, but it may not have been. So I won't name but it was a chief patent counsel at a large company, and he talked about this very issue of surprise, and he said, "Don't give me that." He said, "I'm not surprised when one of our competitors gets a patent issued." He said, because I know what our competitors are doing, because I watch what our competitors are doing. And I have a list, he said, I have a list of applications from our competitors, or even if they're not yet competitors that are in spaces where we're involved, where I looked at them and it caused me to, maybe worry a little, or to scratch my head, or to be, what is the office going to give them for this? And he said, so I, every couple months, go to the file history and look and see where they're standing. And he said, it can be done. He says, I just don't buy this came out of nowhere, where a lot of people say, because in the trademark space, you have to do that, because you don't ever want damages, because the damages could be so great you may never come back from it, right? I mean, for a lot of people in our age bracket and younger and older, I mean, if you were alive during the BP oil spill, the initials BP probably mean something very different to you. I always tell people who are like you and I, we were young at the time, but when Tylenol, cyanide was being put in Tylenol, right? And it turned out there was just one or two people trying to cover for murder, and it was directed at individuals, not a mass murder or serial killer or psychopath situation. But to this day, if you remember that, somebody says Tylenol, what are the first three things you think of Tylenol? And for me, cyanide is one of the top three, because, and maybe I was young, impressionable, and my parents were worried about Halloween, the candy you get. We were able to go trick-or-treating, and we had to throw it all away. The only candy we could keep were candy from people who my parents knew, and then the candy that they gave us, So maybe the Tylenol thing and the scare right at that time when I was very formative, maybe that means something more.
That's a great point.
But these things matter, right? I mean, do you have any thoughts on that?
I mean, I think you're right. Timing is everything. Sometimes, and we talked about this a bit earlier, you can't stand on the beach and hold back the water when the tide is coming in. You have to find ways to work with it. I think, in terms of our system, we have to recognize sort of the geopolitical dimension, that competition with China is in a different place than it's ever been before, certainly in our lifetimes, that technology has changed the way that people use and access all sorts of information and tools. And, but we have to just keep bringing it back to first principles. I like to talk about the Wright brothers, when they got their airplane off the ground, it wasn't because they overcame the laws of physics. It was because they figured out how to harness them to enable flight. The same is true of economics. You can't just disregard the principles of supply and demand. You have to harness them to get the objectives you want. Too often what we see is people trying to force issues in ways that the market just won't support.
So, and that maybe is what really bothers me, right? Yeah. Because it seems like, to go back to the Tylenol BP thing, to just wrap that up, is in the trademark space, you're expected to monitor what people are doing, because if somebody injures your own mark, it may be game over, or the reputation damage may be so enormous it takes for a very long time to come back from it. So you can't allow damage to happen, so you can't be surprised. You have to be very proactive. And on the patent side, we seem to say, oh, well, they can't be proactive. We can't expect them to be proactive, and it seems like forgiveness for really bad business decisions. And because if you're operating in a business, you have to know who your competitors are. You have to know what they're doing. You can't know what they're doing behind closed doors today that's trade secreted, but you got to know at least all the public stuff, and you have to be guarding for that. And if the watch companies had been doing patent searching, they would have seen about 7 or 8 years before Apple came out with their first iWatch. Well, Apple is starting to get increasingly more patents on watches that do increasingly more interesting things. Is that because they might be getting ready to go into the market, or are they just getting those because those are important inventors they want to keep happy? And I don't think that's an Apple ploy. When Apple is devoting resources to something, it's because it matters.
Right.
And we forgive companies for not paying attention to what their competitors are. And then when they come and say, oh, this shocked me, this was a surprise, I didn't know about it. But you could have, and you should have.
Yeah, I'm sure you're right, and that there's a level of due diligence that has to take place that can prevent a lot of surprises. At the same time, in the short time that I've been working in the IP space, we saw first the 10 millionth patent, then the 11th million patent. And I went back and looked at the timeline for when we passed the million mark, and then and it's a very steep curve, right? We went from 10 to 11 in the blink of an eye. Maybe we're well past 12 now.
We're 12, over 12.
Okay, so and at some point, it's got to become very difficult to keep track of all those claims. But an AI really ought to be able to do that, and ought to be able to identify in advance, which claims are going to bump up against some other claims. And maybe that expert in the field that you talked about, the business leader, should know that. Mm-hmm. But on the other hand, it would be great if everybody knew it, because the system was built that way.
Well, yeah, I think we are getting to the point where the systems and tools allow you to do that. So that argument becomes less and less interesting or persuasive in my book, literally every week, as these tools get better and better week to week, it seems.
Well, and a lot of the the folks that you work with that sponsor some of your webinars, for instance, they're working in exactly that space, is making these tools available. I'm always shocked and impressed by what they can already do.
Yeah, and it just keeps getting better and better and better. And that has to factor in, and to cascade for a minute, like the federal circuit still seems to live in a world where to determine whether or not there's venue to sue you in this particular location, where the server is actually plugged into the wall matters. Come on. It probably never should have mattered ever, but I can understand them doing that like 30 years ago, even 20 years ago. But in 2024, especially after the pandemic, most people don't go to an office anymore 5 days a week. Some don't go at all, ever. And you can live all over, even examiners live literally all over the country. And we really still are tied to where is the server plugged into the wall? It seems to me just like the law, which is always at a disadvantage because it always has to play catch up. But it seems like it's getting slower and slower and slower at catching up. And I don't know why that is. Is it because the judges are old and set in their ways, and they most of them, I would think, still grew up in an era where there was typewriters or word processors. I know when I first joined the firm right out of law school, they had just started using computers. And they had typists come in, and they had a third shift. I mean, people don't realize this. Law firms had a third shift where people came in as everybody's going home, and they worked overnight to type up all these tapes so that they could be there on the partner's desk in the next morning. We live in a totally different world.
Right. You may have more insight into this than me, Gene, but to be kind to the courts, it feels like often the principles of a case, especially in some of this cutting edge stuff, like AI, the principles that are implicated are more obvious in retrospect than they are at the time. And I often think some of the poor decisions, the poor precedents come when all of us fail to see what's really at stake in a given case. Sometimes it's obvious from the get-go,
right.
In which case we all need to jump in and defend those principles tooth and nail. Other times you don't realize the implications until later, and then you have to go back and try to fix it. And oftentimes the sort of the force of precedent or the inertia that becomes embedded is just so difficult to overcome.
Yeah, it's gotten harder and harder and harder to undo certain things that people look at. And I mean, even the Supreme Court in the the Kimball case said, this rule, it's been around for 50 years. It doesn't make any sense, but it's been around a long time, so we're just going to go with it because everybody's already ordering their affairs based on this rule that if we were to decide today for the first time, we probably would decide it differently. And it's like, so even when everybody agrees that it's the wrong rule.
Well, ironically, that's kind of the argument that's being made against, injunctive relief at the ITC, right? Well, this is one small, facet of a multi-thousand faceted product. Are you really going to allow that disruption? Those are, yes, there's a point there, but you have to, if you're going in the wrong direction, hitting the gas is probably not the best idea.
Right. And if you allow a little bit of stealing, pretty soon you don't have a little bit of stealing. You have a lot of stealing.
Right. And you have less reliance on the protections that are supposed to prevent stealing.
And why this is shocking. I mean, we're watching this experiment go on to a large extent in many cities in California, for example, where they very publicly announced, we will not come after you if you steal $999 or less. So what it created is almost like a organized system where people would come in a bust and everybody would steal just under $1,000 and totally wipe the store out. And famously now you have major companies, a lot of drugstores have abandoned the worst neighborhoods in those areas because you can't allow people to just come in and steal up to $1,000 and walk out and have no repercussions. I mean, what are people going to do? Of course they're going to, not everybody will, but so many people obviously do that you can't live with it.
You talk about the United States and why our country has been as successful as it has for as long as it has. And for me, it comes down to liberties, individual liberties, markets, commitment to markets, right there, rule of law. There is a Peruvian economist, Hernando de Soto, wrote The Mystery of Capital, and he was, sort of wondering aloud and exploring why democracy worked so well in the United States and wasn't working nearly as well in the other countries. I think he wrote this maybe in the late 90s, but his thing was the size of the informal economy, and he was really focused on that. How do you get people operating in the informal economy to become part of the formal economy so that they're registering as businesses, that they're paying taxes, that they have access to police protection, that they have an address where they can receive bills, receive payments, where they can be served with court papers, and that all of these things that the United States did provided that rule of law context that allowed markets to operate effectively, allowed that economic dynamism, because it took all the friction out of the system. And, when we failed to provide rule of law, whether it's in a store or at the border or in, intellectual property, then the system starts to break down and we don't have those dynamic benefits of a market economy.
Wow, that I think is, I'm glad the conversation went long enough to get that out, because I think that is extremely insightful. I think if you were I'm going to think about this more, but we got more conversation to have on this, I think, because if you were going to put your finger on one thing, it's got to be the rule of law.
Yeah.
And the certainty that comes with that.
And it's rule of law, not rule by law. What you see in countries that have become more authoritarian is, the system is used against itself, to force through changes that actually override the protections that the law or the Constitution are intended to provide. And so it's a very fine line. I think, you see in China oftentimes that rule by law dynamic where, we hear that in the IP space, for instance, 99% of the time you'll get a fair shake, but if the government really wants what you got, they're going to put their thumb on the scale. And so the most important thing then is to make sure that we've got those checks and balances that prevent the government from putting its thumb on the scale.
Yeah, absolutely. Because if you're talking about spending billions of dollars in research and development over many years, you can't run the risk of you being the 1%.
And the more successful you are, the more likely you are to be
The
in the
1%,
crosshairs. Right?
yeah. Well, great. This was a wonderful conversation. Hopefully we could do this more often. But I learned a lot. I always learn a lot when I talk to you. So thank you very much for coming out.
Likewise. Yeah, thank you, Gene. It's always a pleasure.
Great.
Yeah.